Well, good morning, everyone. On behalf of Wisconsin Lawyers Mutual Insurance Company, I would like to thank you very much for joining us for WILMIC's 2022 Winter CLE program. My name is Matt Beier, and I am WILMIC's Senior Vice President. This is one of two 3-hour CLE programs provided to WILMIC policyholders, in addition to our all-virtual free CLE Fridays with WILMIC. New dates will be coming soon, so stay tuned to your email and figure out when those are so get them on your calendar. We have an excellent couple of programs to offer this morning in the area of family law, and then estate planning will be our second program. Two areas in which WILMIC has seen an increase in claim activity in recent times. The first program is titled Legal Malpractice in Family Law Marital Agreements. This program and the second program have both been approved by the Board of Bar Examiners for a total of 3 ethics credits. It will appear as a live webinar when you report your credit and you search on the BBE's site. That's the way that you'll go about finding it. Our speakers for the first program are Brian Anderson, Claims Director at WILMIC, and Attorney Marta Meyers. Brian Anderson is here, and he's on time, which is more than we expect from him, so we're already ahead of the game there. In fact, Brian just celebrated 19 years with WILMIC. We might have lost him on that comment. Brian just celebrated 19 years with WILMIC, and he is our Director of Claims. He works with lawyers in resolving malpractice claims made against our policyholders. He enjoys the challenge of helping place policyholders at ease during a time of stress when they're facing a legal malpractice claim or grievance. Before joining WILMIC, in 2003, Brian practiced personal injury law in Madison and served as legal counsel for an insurance company. He began his career in general practice and is a 1992 graduate at the University of Wisconsin Law School. He serves as on the content planning committee for the State Bar of Wisconsin Solo Small Firm Conference. Brian just celebrated his 19 years this month, and it just so happens to be the same month as his birthday. He also turns 19 on December 29th. So on December 29th, be sure to wish him a happy birthday. Joining Brian is Marta Meyers, and she is joining us by Zoom this morning. Thank you, Marta. She's in Texas, and she is currently enjoying much better temperatures, I think, than we are. Marta is someone, she's a lawyer who recognizes that people are choosing to change the way they settle their family law disputes. They are choosing to resolve the matters more humanely, more efficiently, and more creatively. Marta and the other members of the Boardman Family Law Group on the cutting edge of family law in Wisconsin and can help clients achieve these solutions. She counsels clients in family law and works with clients in all process options, including collaborative law, mediation, and more traditional negotiation and litigation. Awards and honors and community involvement are aplenty with Marta. She has an AV rating from Martindale-Hubbell. She was named in Best Lawyers from 2008 to present. She's named in Wisconsin Super Lawyers from Wisconsin from 2006 to the present. She is a terrific lawyer, and we look forward to her contributions this morning as we go through the presentation. So, a couple of quick notes, or at least just one. For all of you in the audience, the mics in the room are hot, and just know that anything that you say might end up in the presentation and recorded. So, with that, I will turn it over to my able colleague, Brian Anderson, and we will be off and running. Thank you.
I see Marta, but does the audience see me and Marta? I
believe they...
Yes.
Okay.
Yes. I can see you.
Oh, good. Hey, Marta.
Good morning.
Yeah, Matt made that comment about the microphones because some of the feedback regarding him was not coming in real great, but that's okay. Secondly, Matt told me the program started at 7, so I tried to be late, but...
it was planned.
Yeah, anyway. So thanks for joining. I know December can be a stressful time. Ethics credits is one of the things on your plate, and we're happy to try to give you a December option there. We do see, from the claim standpoint, there's definitely some uptick in December, and I think there's just some general stress that clients are feeling, that attorneys are feeling, and I don't know, Marta, what you see in your practice, but December, like Matt said, it's my birthday month, it's Christmas, all these fun activities, December holiday parties, but as I get older, unfortunately, I'm recognizing December is not necessarily an easy month for clients, for practitioners. Now I realize why my parents were so stressed with my birthday. It kind of seemed like an afterthought on 12/29, I'll admit that. But Marta, do you see some of that in your practice with the family, the stresses that come with the holidays and the impact on family law and clients?
Absolutely. There are so many people who really get emotional, right? And then you don't see it, but you know that the emotions are there because of all that nostalgia, memories of childhood, holidays, the stress, the pressure. Yeah, and actually, I think a lot of us really try to push things off in December if we can, just to alleviate that stress and, let people concentrate on more important things. Well, I mean, obviously their legal issues are super important, but timing, right? Timing is important. So yeah, absolutely. December is a tricky month.
Yeah, and we'll talk about timing with legal malpractice insurance policies and reporting too. I know I've had a couple of things reported this month whereby, I was just going to say where people were concerned about getting it reported to us before their policy expires at the end of the year. Mr. Watson has something over there.
Yeah, hi, Brian.
Hi.
Matt, and hi, good morning, Marta.
Good morning.
Good to see you. Hey, I had a question for you, Marta. You were talking about timing and how December brings on that stress in families and in family law, and Brian mentioned it too. Can you talk about some of the pitfalls or the minefields that lawyers should be aware of and try to avoid, maybe some issues that come up that can trip up a lawyer, this time of year, whether it's custody issues or, placement, and that kind of stuff with the holidays. I know, I remember my family law practice, there were just some things that would come up that maybe were not anticipated. And I'm just wondering if you have some thoughts for our audience about what to look for to not get tripped up by those things.
Well, in my experience, it's really common to have, in a divorce situation and a family law situation, have one person who's been thinking about it, planning it, really ready to file and to move forward, and the other spouse is caught unawares or seemingly unawares, and that can really cause a lot of chaos and added stress to people. And then when there are children, add that into the mix. There was an article I saw from the ABA several years ago that I printed and I handed out to almost all my clients every year, and it was written by adult children from divorce who said how their parents ruined the holidays for them forever because they got in fights and in turmoil and started talking about divorce like right before Thanksgiving or at Christmas. Sometimes people can't help themselves, right? But honestly, when I give that message to people who are in the thinking stages or, they are seeing me in November, I really ask them to think long and hard about the timing so that because it can affect so many lives.
Well, boy, we're really giving a great message for the holidays, aren't we?
I know, right?
But
sorry, that's my business.
But as I say, I've had a lot of activity in the claims front this month, and there are definitely a couple that are clients under stress that are lashing out, and I think it'll be okay, but it's a real risk, so it's something worth mentioning to the audience.
Yeah.
So we're talking about legal malpractice, and we're going to weave in the first half of the program is on divorce, family law, marital agreements. We'll cover all that. But the first element, if you are concerned about how one can bring a claim, and it's going to be interesting because the second hour will chip that back away. But first, you usually need, or you should have, a client that would bring a claim. I mean, if you have to establish an attorney-client relationship. So to establish the duty, the negligence, and we'll go down the four elements. But In the second half, Matt, we'll chip back away at that and say, well, who is your client, and do you have to have a client to bring a claim? Estate planning is the one area where that has, in fact, I would say the majority of the claims we see in estate planning come from a non-client. The disinherited beneficiary, or the one that thinks they've been disinherited by some negligent act in the way the lawyer provided services to mom or dad, is the kind of the basic, most common element we see there. But in this case, it's usually pretty obvious in the family law setting as to who your client is, and therefore you've established an attorney-client relationship. Hopefully you've sat down, entered into a retainer agreement, a scope of retention, what you are and what you are not going to do. But I think one risk there, Marta, would be I guess two things I want to bounce off you. One is the person who calls or just is generally dissatisfied with their attorney, just want to see what you think, Marta. How would you do this? Try to suck you into a case where you're just trying to be helpful. And I'm picking on you. Nothing has to do with anything Marta did. She's a practitioner.
Fine.
But the second piece is where two people come to you, and we'll talk about that in the context of the marital agreement. Husband, wife, you represent husband or wife, but it's a danger there, Marta, whereby the other side the dissatisfied side later might say, well, I thought you were helping both of us out, or I relied on you and now I realize this isn't fair. You were my attorney, I thought. So two questions. How do you keep yourself from being dragged into the person who just wants you to look something over, or the cocktail advice, and then how do you handle it when it's clear that husband and wife want you to represent them?
Yeah, well, I'll handle the second part first. So that's pretty easy, and I think almost everybody understands that there's just no way you can talk to both a husband and wife about marital agreements, right? I mean, there's just no way you can do it. And I think most people are pretty good about, most attorneys, about saying, look, I'm going to draft this, but I'm only representing one spouse and the other spouse must have independent consultation. So I think that one's fairly clear. The cocktail advice, I mean, that can get tricky too, but I'm pretty good at this stage. I kind of have a set speech, like, you know what, I'm off the clock. I'm not going to talk about certain things, and you can always call my office if you'd like an appointment, right? That is the way to handle it, where we have the protocols, where we run the conflict check, where you do it by the book, because the cocktail hour, first of all, it kind of ruins your cocktail hour, right? Right. But secondly, it's just such a bad idea to go down that path because, because I've been to your seminars before, and I know that if prospective clients think that they're talking to you as a lawyer, then you're in trouble because you're talking to them as a lawyer.
Yeah, and we definitely have had claims exactly that way, where you're just not privy to all of the information. You're answering the question you think is the situation based on the facts, limited as they are, that you have. As it turns out, there's a lot more to the story. I know, Tom, you like to use that one. Let's get what's Paul Harvey or whatever, the rest of the story. But where if you sat down in a formal setting, your advice might be totally different, because you say, oh, I wasn't appreciating X, Y, and Z. And so I think that's sound advice, Marta, and it cuts against what I always say, and I'm a sucker for it, where lawyers are helpful, try to be helpful. That's why you got into the business. And I think family law particularly, you're trying to be helpful, and saying no doesn't feel real good. But it's the best advice for you and the client often, and always. From a legal risk management standpoint, it's always the best advice, but it really is putting yourself out there at a risk when you're trying to be helpful can backfire badly.
Yeah, it sure is. And just to follow up on that comment, it is sound legal advice. It's sound practical advice so that you can enjoy your cocktail. But it also is an ethical duty. And so one of the comments to 1.3 in diligence, says that any confusion about the attorney-client relationship needs to be cleared up by the lawyer, and preferably in writing. I don't have the comment directly in front of me, but that's the gist of it. Legal advice, practical advice, and certainly to be in line with the rules of professional conduct.
Now, I do want to follow up, Marta, on that. I knew you would probably say that regarding the representing both husband and wife. What happens when, or what, if anything, can you do when the other spouse says thanks, but no, I'm trying to save money. I'm just relying on you and my husband's attorney, or you, as my husband, whatever. Or do you ever provide names of referral potential attorneys that I would recommend you talk to Tom Watson, or do you leave that to that unrepresented party to find independent counsel?
I think it depends, but sometimes I will never give just one name. So if I do recommend someone, I'll give usually 3 different names and say, everyone has a different style, and it's never one size fits all. So, and then oftentimes I'll refer to the state bar because the state bar has a referral service as well. Yeah.
Okay. Matt, do you want to, since you're up there on the stage, do you want to go through the other elements, or I hate to have you stand there doing nothing. No. That's what he does at work. I thought you might come here ready.
Right. Good shot. But no, please feel free. Carry on.
All right. So we talked about the existence of an attorney-client relationship, and I think we've covered that. And it's usually fairly obvious in a family law setting, and it is going to be something I want to talk. We'll definitely talk about a lot in the second session. Negligence, and this is one we're going to dig into. But the standard to have a legal malpractice claim, you must establish that the attorney was negligent and breached a duty owed to the client. And I'm going to talk about a trial we just had in August, whereby a marital agreement drafted by an attorney was struck down, invalidated by the divorce court. But in the end, the jury and our expert followed the advice of our expert, finding that the attorney did not fall below the standard of care with regard to the agreement that was presented and invalidated. And Marta, it's going to be, I'm interested to hear your thoughts later on that part of it. But usually that highlights the fact that there usually needs to be an expert involved. Very rarely can you establish negligence without an expert, because the jury is not a jury full of attorneys, and attorneys may have different opinions about what they think was best practice, but we're talking about standard of care, and that is, did the attorney meet the standard of care? Doesn't mean it's a guarantor that everything they did and drafted will be upheld forever after, and that they're a guarantor that they put a stamp on it that because I drafted this, it's ironclad and you'll have no problem. That's not the standard. But we are going to talk about the advice that you want the client to have informed consent, so they know that, yes, we did this, I think it's solid, but there are risks. And as long as the client's fully advised and you covered things as best you can, there can be situations, as we've found out in August, whereby an agreement is invalidated for reasons that may or may not have been in the control of that lawyer, but there was no negligence. So anyway, it's an interesting concept. I think clients might think that, often leave an attorney's office thinking, well, I went to an attorney, they drafted an agreement for me, I'm protected for now and ever after, and if anything ever goes wrong with this, I'm going to go back against the attorney. Well, that's thankfully not the standard of care. So the third element is there has to be a causal relationship between the duty owed and the damages. And in this case, that was obvious, whereby an agreement was invalidated and the client looked to the attorney for the difference between what they would have paid the other spouse had the agreement been upheld versus what they ended up entering into a settlement for. And that was the damages, and they were very much collectible and calculatable, because it would have been a zero, 2 million zero, and it ended up being roughly $1 million kind of settlement. But Marta, and I'm curious to see your thought on, do you ever draft or talk to a client about a marital settlement agreement that's fairly one-sided with the idea that this will maybe be challenged, but it will set you up at least to negotiate a much better potential settlement in a divorce than had you not entered into an agreement in the first instance? Or is that too risky to try that strategy?
Well, that's a really good question, and I think it needs to be thoroughly discussed, and it should be a client-driven result, or the client's choice as to how he or she wants to handle that risk. I think the complete opt-outs, as we call them, it depends, right? Brian, it totally depends on the factual circumstances of the couple, right? So when you have the second marriage and for both parties, and they have children from the first marriage, a total opt-out where each comes in with what they have and they leave with what they have without commingling and without creating marital property, that is more of a natural sort of situation than first marriage. You have one spouse who has some substantial wealth and the other spouse who doesn't. Those are the trickier ones, and especially if you're younger, first marriage, you're going to probably have children, and maybe the non-moneyed spouse is going to be the caretaker of children and not be earning a lot of money. If you do a total opt-out under those sorts of circumstances, I think you're just asking for complete invalidation. But that's just my own opinion, right? So that's what I think based on my experience. But I think it's up to the client if they believe that it gives them a little bit of it's a factor certainly for the divorce court to be looking at the marital agreement and the terms and what the parties intended and what they signed. But, those are just very different factual circumstances. And I think that's a pretty huge risk. And I would not typically recommend a complete opt-out for that situation that I just described.
Just on the note of negligence, Brian, and proving it, I do want to be careful in how we come across, and don't ever do this, don't ever do that. But I can add a couple of modifications to the general cautionary notes that we're offering, and that is that the case that's not in your materials, or maybe it is in a different location, is Helmbrecht. 122 with second 94.
That's in the family law line.
There you go.
Yeah.
So it's already there. So and I guess I'm just sort of emphasizing the point that generally an attorney is not required to exercise perfect judgment in every instance. If the results are guaranteed, that's the real error. A lawyer is not a guarantor of results and would not be held accountable for an error of judgment if he or she acts in good faith and his acts are well-founded and in the best interest of his or her client. So it's okay to make errors of judgment as long as what the judgment that you're making, the advice that you're giving is well-founded, has a reasonable basis, and is something that other attorneys would do under the same or similar circumstances. So it's okay to be wrong, even if your judgments are later found or determined by a court to be erroneous. Again, if you're making reasonable judgments that are based in law and are have a practical basis, then you're not doing something wrong as an attorney. And really, I consider that sort of fleshing out every consideration that you can for an attorney and doing a good job by your client. Do you agree, Brian?
Oh, totally. And I don't know why this made me think of that, but one thing that's challenging, and Marta, you've been at it for a while, is the statute of limitations in Wisconsin is not friendly to practitioners. And family law is a perfect example. It's the discovery rule. So Marta could meet with a client and have an agreement signed today, and 20 years from now when they get divorced, hopefully not, but that's when they will be scrutinizing the work Marta did in 2022. And it's when the agreement is invalidated by the court that the client knew or should have known that, hey, this was invalidated because of something Marta did or didn't do back when we signed this agreement. I mean, that would be the claim. And that really is a challenge, I think, for two reasons. One, when they see you, Marta, they're probably at their best behavior. They're getting along as well as they're getting married. I'm pretty agreeable. I realize I'm not getting a fair deal out of this, but hey, we're in love and happy. And I want to get back to the sad, angry theme of December, which we're trying to stray from. But it's true. I mean, I don't mean to, like, I'm not trying to make light of it, but I mean, people, there are things that happen that you couldn't anticipate when they were in your office, that they didn't anticipate, obviously. They weren't thinking they were going to get divorced. That the dynamic is completely different when they're getting divorced, and as estate planning too, we'll talk about that in the second half. There were some things that put stress on a family that the lawyer couldn't appreciate or anticipate, and therefore they're going to pick at things that you didn't anticipate when you drafted the agreement. I'll just say that. But which brings up 2 points: is that it's a claims made and reported coverage as legal malpractice, and obviously we're at a legal malpractice company, so it seems easy and understandable to us. But one thing that you want to make sure is that if you are retiring from the practice, and these two areas of law I think are important, family law and estate planning, it's when the claim is made and reported. You want to have coverage in place when and if a claim is made and reported, for there to be a policy there to protect you. And that can be a long time after the work was done. And so that's just something, I don't know, Marta, if you're ever thinking you might retire or something, but.
Oh, yeah.
but
yeah. But
yeah,
you know, there's only so much you can do on that front, right? Knowing that these things could come back. I mean, you just make sure you have good insurance in place. And I guess I have a question for you, Brian, too, which is, you know, the whole issue of how long do you keep your file? Because, you know, you can do your CYA memos and like client understood this or what have you, but then we don't have a legal duty to keep that file for 20 years in the event that people get divorced. So, right?
That's true. I don't know, Matt, if you have any insight better than but I know Marta's, there are certain files where you may have a little bit of a feeling that I agree, there's no legal requirement that you keep files forever. And most claims happen within the first 3 years of the mistake. But family law is unique, especially when we're talking about marital agreements, can be quite a bit down the road. It seems as though attorneys have computer access generally to most of the important documents, materials as needed. Matt, do you have any better insight as to how long he should keep?
Well, here's what I can say. When Brian and I receive calls from our policyholders, and it's a suspicion of a claim, or their spidey sense, their lawyer sense went off, and this might turn into something, and they report it. One of our first questions is, okay, well, what's in your file? Yeah. And so if you don't have the file, we can't answer those questions. So I think the answer, at least the first part of the answer, has to be keep it forever.
Yeah, I know.
And I think the good thing, and again, if we're looking at silver linings of, the pandemic that we're going through still, it's that technology has really been thrust to the forefront in a lot of ways, including, electronic storage of documents. So I don't think it's terribly difficult anymore. I don't think it's terribly expensive or inconvenient. I think those excuses have gone by the wayside. And we do have now the means to preserve files much more efficiently and much more with much more volume than in the past. We don't have to go rent a storage unit, to keep that file, forever. So I think, that has to be at least the first answer. And
usually the file is the attorney's best friend in the end. I mean, yep. I know it's a pain, Marta, and I appreciate that you don't need to want to keep banker's boxes full of materials, but it is usually the best friend, and it helps you remember what you did and when. The other one, the billing statements tend to be a huge area of interest for legal malpractice plaintiffs' attorneys. They just scrutinize the daylights out of the billing. And anything that's not on there means that you never met with that person and that never happened. I'm curious, Marta, do you do anything on a flat fee in the family law arena? And if so, how do you? No. It's out.
No. Some lawyers have experimented with that, and there is one law firm Wisconsin that advertises and markets itself as a flat fee law firm I'm aware of, but it's just really, it's problematic because, well, less so in marital property agreements because those are fairly contained and they're discreet, but certainly in other family law matters, it's just too difficult because of all the variables that can affect the legal process and, how long it takes and how difficult or how easy people are to work with. So, yeah, the flat fee thing does not seem to be a popular way to go.
Yeah. Well, I was going to see, even if I would recommend, especially having just sat through a trial where the lawyer was scrutinized, that even if there is a flat fee in place, and I say this for personal injury plaintiff attorneys too, although I know I did that and didn't do it, but to have an actual, even if we're on a flat fee, the date and time spent with the client, and if it's a no charge, great. But that tends to be something they try to make the plaintiffs, legal malpractice attorneys really try to emphasize that, well, you didn't spend any time with this client, you never met with them, you didn't do that. And then the attorney says, well, yes, I did. I know we met twice in my office. And if it's not on the bill, it doesn't look great in front of the jury because the jury is saying, well, lawyers write everything down, and now this lawyer says I met with them, but there's no record or no note. Lawyers bill for everything, don't they? I mean, there's a little bit of the jury has a feeling of lawyers that's not quite as good as we might have of lawyers. And I'm serious about, I think I like lawyers, but there's a feeling that, so I'm just trying to emphasize, put it down, October 3rd, met with client, point 3, talked about this, no charge.
Yeah, Brian,
that's great.
You make a good point.
Yeah.
And that's, it really gets to Rule 1.4, which is all about communication and how are you communicating with your client. And this is, billing is one of those opportunities, rather than, an exercise that, is annoying or is pushing papers across or whatever you might consider it, reconsider it as something that gives you an opportunity to communicate with your client. When I was a young lawyer, one of my mentors said to me, make sure you put everything down that you do on the file, because when the client gets the bill, it's one of the few things that they're going to read. We're expensive and we cost money, and people tend to pay attention when they're identifying exactly what it is that they're paying for. So even in a flat fee arrangement, it's still important to record your time. You never know when those things will come back. And as far as, just to circle back to the file retention issue, there are other considerations. Brian mentioned the statute of limitations, 3 years. That may or may not be applicable. Usually when folks go through litigation or a criminal defense or something like that, the outcome is known, at the conclusion of the representation. So there isn't much use for it beyond 3 years. Brian's already identified in the area of family law that there may be claims that arise much later down the road when the error is finally realized, and that's the tough part about the discovery rule, is that what should be 3 years on tort or 6 years on breach of contract suddenly can turn into 20 years. WILMIC, we have had a claim that's come in more than 20 years after the initial error was made because the injury wasn't known until that time. So I do see that we had a comment about file retention from one of our revered audience members. Tom, did you have an addition?
Yeah, thanks, Matt. I just was going to comment on how long should you keep your files? And as you guys know, at WILMIC, we get that question all the time. And I know the rule of thumb is often, 7 to 10 years and that sort of thing. But as you guys articulated, as did Marta, there are instances where that isn't always the case. And I just wanted to mention, I just got an email. Now, I haven't been in private practice since 2005 when I joined WILMIC, but I had a divorce client in 2004. They reconciled and went on their merry way. And I just got an email from her last week saying, hi, Tom, I hope you're doing well. I hope you remember me. Reggie and I used you back in 2004. We've been married all this time, but now we really are getting divorced. And I can't find my prenuptial agreement, and I wondered if your old firm had a copy of it. So you're going back 18 years, and I, hooked her up with my old law firm and see if they still have it. And so, that's 18 years. Now, I think that's an anomaly, but you run into that every once in a while. I wonder, Marta, if you run into that from time to time. And then, Matt, you were talking about, people who save all their files, and you guys probably have been at firms too, like I have when we visit them, that I've been at firms where you go into the basement and they're showing us, an entire room full of boxes and boxes of files. And in this day and age of electronic storage, now it should be much easier to save files. But the question is always, do I really need to keep something for 20 years in a family law situation? Occasionally it'll come up, like it did with my old client looking for her prenuptial agreement from 18 years ago. So I don't know, Marta, it's impossible to cover for all of those circumstances that may arise, but occasionally they do.
I mean, that's a really unfair burden. And I will say, right, and I would also say that, that brings up the importance of closing letters. So we do that with every single case, right? This matter is now closed. We will not keep your file, right? Keep your legal documents in a safe place, because we are not going to keep this file past whatever. I think our firm says 6 years. So I think that should be some protection for us, right?
Yeah. Do you know if the firm sends out a letter at that 6 year, whatever that mark is, saying, just reminding the client your file will be destructed at month's end, years at whatever, or is it?
No.
But
I don't, not for family law, no. We conclude the matter, we send a closing letter.
Yeah.
And say, we are closing your file.
And a lot of the documents are available at the courthouse or otherwise in the family. There have been litigation, it's all on file, hopefully. But, sorry, you got a
I was
question?
just going to ask, isn't a marital property agreement more like estate planning documents where you're anticipating that if it's going to be enforced, it would be at a future time? And in practice anyway, I've seen estate planning files get kept forever, and somebody's job was to look at the obituaries to see when they could clear the files out. But I'm just wondering whether it sounds like there is no different standard that applies to a prenuptial agreement.
No, and as mentioned, usually it's a pain in the neck, but like Tom said, most of the time it helps the lawyer recall and or defend themselves about what was done and why. So I know the urgency, you feel like getting rid of that stuff, but that's where I said if it's on a case-by-case basis, sometimes you just have a feeling about, this one, there's no way I'm going to ever hear from these clients again, or this client again. So this one, this person was litigious. So it is on a case-by-case basis. I realize, Marta, you have a uniform standard that goes out to all clients. But even with it's tempting sometimes, though. Maybe this one just don't feel like I'm going to hold something back just to make sure. Because OLR, it's a 10-year, right? Look back.
It's not. It's actually changed to 6, Brian.
Oh, good. Okay. Well, then that's better.
It's better than, it buys us 4 years, right? Yeah, but you're right. Once upon a time, it was 10 years. And so and what Brian means is that a grievance can be filed with OLR for many. I think it was changed in about 2019, 2020. Grievances could be filed by anybody, up to 10 years, past the alleged error or the grievance, I guess. And that was changed to 6. Now, OLR has a tendency, even if the error was, as described by the grievant, as being something that's older than that statute or that rule of repose, I guess, they'll still knock on your door, and they'll still say, "Hey, this happened. What can you tell us about this?" And it wouldn't surprise me, I guess, if OLR decided to hang its hat on, the entire file. And we can talk about, what sort of coverage, WILMIC's policy for certain, and most malpractice policies will provide to policyholders in that instance, specifically grievance counsel. And you want to talk about that a little bit, Brian, or you want me to, or?
Oh, sure. Yeah, go ahead.
So grievance counsel coverage is available in WILMIC's policy, and it's essentially, a means to sort of not sidestep, but handle, the responsibilities that you have as a lawyer when OLR begins or inquires about any particular grievance. And so what happens is WILMIC will work with its policyholders to provide or hire grievance counsel. It's a good idea for a lot of reasons. One, you're busy. You're not going to get paid for defending a grievance before OLR. And so why not hand that off to grievance counsel to defend you and handle the lion's share of the work? Two, it also helps keep OLR on, within the parameters of the grievance. So rather than conducting what I refer to as, sort of a plain view investigation where they, invite the entire file or whatever response they can from you and then sort of go down each, or pull at each thread that they see, let's keep them on the one grievance that, is at issue here and successfully defend that one. Finally, I think it removes stress from you as a lawyer, and really, takes away the emotional element that you have when somebody challenges you and your license. So for all those reasons and others, I think it's useful to make use of that part of your coverage. So know your policy. It's certainly in your WILMIC policy, and make use of that additional benefit that's available to you. We've strayed from the initial question, but
No, but that's, and obviously to use that service, you have to report the matter to WILMIC. And so don't think because it's a grievance and it's just about fees or something, I don't know if I should even bother my carrier. Report it, at least at the very least, you'll talk through it with someone and get it off your chest. And then, as Matt said, there may be a benefit to having outside counsel, which, by the way, brings up a thing that comes up quite frequently is, can I, on the file retention or file request, attorneys will say, all right, it's a pain. This person's requesting their file materials. I'm going to have them sign an agreement that they won't file a claim or grievance if I give them their file. That's a no-no. You cannot, under any circumstance, prospectively prohibit someone from filing a claim or grievance as a extortion attempt to keep their file materials. Even though it's tempting, just don't do it. The file belongs to the client, and that you can't under any circumstance, even when settling a legal malpractice claim, prohibit someone from filing a grievance. It just, the SCR rules have a specific, I should have wrote down what that rule is, but I know it's in there. But anyway, so don't do that. You can settle a claim with a client, with or without notifying your carrier, as long as that client's been advised of the right to independent counsel and have the opportunity to consider their options. Sometimes the lawyer wants to just say, you know what, I'm sending $1,000 back. That's what I'm going to do. I don't want to deal with this. That's fine. As long as that client has been advised of the right to discuss their options with independent counsel, you're protecting yourself and the client then from scrutiny on the settlement. Yeah, I get really far off field now, but actually,
let's circle back a little bit here. Maybe we can talk about proximate cause with respect to family law matters, or
yeah, I was going to say, are we? Is this till 10?
Till 10, yes.
Yeah, maybe I better. Let's fast forward to the marital agreement itself, and Marta, we did have a trial in August whereby the court Well, the issue was the lawyer negligent? It was a legal malpractice case wherein the client sued both the lawyer that drafted the prenup or postnup in our case and the lawyer that handled the divorce, because he was critical of our lawyer for not drafting an airtight enough marital agreement and critical of the performance of his divorce attorney in that not doing enough to make sure that that agreement was upheld at the divorce hearing. And there were some, the good news for WILMIC was that our insured that drafted the agreement was found to be not negligent. The attorney that, as it turns out, wasn't insured by WILMIC that handled the divorce was found to be negligent in the manner in which she approached the divorce, and in the way that she went about, I always think of the term as kind of defending the marital agreement. There we go. There were some mistakes clearly made, but to understand the whole concept and the risks that lawyers have in this area, the Button case was referred to about 3,000 times in that divorce, in that legal malpractice case. And the interesting thing is that goes back to 86. I mean, usually you get something more recent that takes over, but this was a 2022 trial, and Button, the three elements in Button were all over the case. And that is, those are as follows. Did each spouse make a fair and reasonable disclosure to the other of his or her financial status? That's number one. Two, did each spouse enter into the agreement voluntarily and freely? And three, were the provisions of the marital agreement dividing the property fair to each party at the time of execution? And I'll add a 3A, was it fair at the time of the divorce? That's a tough road to hoe for the attorney. Let me put it this way. I think there is a tendency for the court in equity to look at the situation before them years down the road, and maybe financials have changed quite a bit, and say, I'm not going to validate this because I don't think it's fair. Is that the lawyer's fault? But we'll take each one separately. First, Marta, obviously an important element is whether there was a fair and reasonable disclosure of financial status. I know one of the best ways to do that is to have financials stapled to and or attached to the agreement. That's not a requirement, but tell me, how do you set? I think the best part of that came out of that trial is if you look at each of these, and at the time the agreement's being entered into, think about how are you going to establish this if challenged later. But so number one, fair and reasonable disclosure of financials.
So that's the easy test to me, right? And the reason why Button was mentioned 3,000 times is because it set the standard, right, for all marital property agreements going forward. And so it is our seminal case that we always look back to, and every reported case after that refers back to Button. But the disclosure part is, that's easy, it's straightforward. And it's just, sometimes there are reluctant clients who feel like, this information is very private and so forth. So, to help protect that, stamp confidential all over the place, and refer to exhibits, which are the financials. I will also say, Brian, when there is a divorce later on, our divorce code says that that if there is any marital property agreement, either prenup or postnuptial, that it shall be attached to the petition for divorce. So you want to be careful. I mean, I never filed the financials that might have been and that would have been entered into at the time of the signing of that prenuptial or postnuptial with the divorce petition, because that would become a public record. But the agreement itself becomes a public record, and that needs to be attached to your divorce petition, FYI.
When it says reasonable disclosure of financials, fair and reasonable disclosure to the other side, I think there's a time element that's important. I talked about the billing statements were scrutinized at the divorce or at the legal malpractice trial. But Marta, a couple comes to you, says they've looked over everything, they understand each other's financials. Is that enough to make you satisfied that they understand, or do you need what can you do to help protect your agreement with the? I
think that's fine to do that, because they are also a lot of the forms will have acknowledgments. I acknowledge that I've received all this. I acknowledge that I've received a fair disclosure and that all my questions have been answered. I've seen some where they'll say tax returns are available. If you want to see the tax returns, we have those, right? I think that's good protection. You know, I don't think you can over disclose on financials just to say, whatever you want to see, we're going to make it available, subject to confidentiality, of course.
Well, the other side attacked, even though this wasn't totally accurate, attacked the disclosure of financials by claiming they were, quote, sprung on the other party at the time of execution. Obviously, that would be a concern, I would assume, Marta, if that would not be fair and reasonable if there's no time for the other spouse to have digested and understood the disclosure.
The timing issue. The timing issue is important, right? So best practice, you make it known that a prenup is in the works so that it's part of the condition upon marriage, right? As soon as possible, even if the drafting gets closer to the time. Yeah. And, you know, sooner is obviously better.
The second element is whether the agreement was entered into voluntarily and freely. And in the trial we had, the trial judge felt, or on the underlying divorce trial, that it was not voluntary and free because the spouse testified that if I didn't sign this, I was of the impression that I needed, that I wouldn't get married, or that there would be a divorce if I didn't sign it. Secondly, there were some, quote, cultural issues that prevented one from asserting their interest or their rights, and felt they had no choice but to sign it. That's a harder one to establish, I think, one way or the other. That's a hard burden for the attorney to make sure, if by all accounts, like you had said, if the other side is represented and their attorney says, my client's read this, understands it, and is prepared to sign it. I don't know what else, at least our expert felt that was reasonable for our attorney to rely upon that representation from the other spouse's attorney. But the trial court makes differently.
That's tough. That's tough. I mean, I'm sorry I don't have the case in sight in front of me, but I'm pretty sure we have a couple of cases that say that you can condition marriage upon entering a prenup, right? I mean, you can say, I'm not going to get married without a prenup. So.
How often do you have you worked on prenups frequently, Marta, or what percentage would you say of marriages end up having some type of an agreement as a part of the couple's marital plan?
You mean in their divorce, whether there's been a prenup?
Yep.
Yeah, I mean, you know, I don't keep statistics, and I would be remiss in trying to say, you know, what averages are, what the percentage is, because, you know, it's very ad hoc, right? So, but we see them quite often, and I mean, you know, I think there are quite a lot of people who have done prenups in their marriage or postnups, and then, you know, the cases that I don't see, Brian, are the ones where people get divorced and there is no dispute that the prenup will be followed.
Right.
And I'm kind of interested to know how often that happens, because in those cases, a lot of times they don't need lawyers, right? They are following the terms of what their agreement was, and it's very straightforward. So I don't know how often that happens. I get the cases where there is a dispute about whether or not it should be enforced.
Which, by the way, the third element is dividing the property fair. At the time of the execution, was the agreement fair in that regard? And I think there also is a review when challenged at the time of the divorce, Marta, but the very purpose of entering an agreement is that it isn't going to be equal. And there isn't going to be a division that's necessarily equal, doesn't equal fair. So I don't know how, do you ever counsel a client that you can go 100-0, and I think this agreement, it looks like it satisfies the three elements. It's certainly not fair in terms of equal division. Do you ever counsel a client that maybe, do you consider giving a little bit, putting something in there, maintenance, otherwise, something that would help overcome the fairness argument if challenged down the road.
Absolutely, and that's what I was referring to a little bit earlier, right? Like it does just really depend on where the parties are at the time of marriage. And, you know, we also have some reported decisions that talk about foreseeability, right? So what is reasonably foreseeable for this couple's future and what isn't? And I usually talk about that. Well, I do, not usually, but we talk about that when we're drafting these things about, you know, not knowing what the future holds. And, you know, good case in point would be like our pandemic of the last few years. Like no one ever would have predicted this, I don't think, in our legal careers, right? And it threw such a monkey wrench in all aspects of our lives. And so you think about those sorts of events and how that can affect a marriage. And now the marriage goes bad, and all sorts of things have happened that the couple did not foresee happening when they entered into it. And it just makes it, you know, a divorce judge is going to look at it very differently at the time of dissolution than at the time they entered it, however many years ago, based on what has occurred in their lives.
Brian, we've got a comment from the
Oh,
audience.
sure.
I don't know if this is for WILMIC or for the speaker. When clients enter into those, it's basically in the beginning of their relationship, and they have all the agreements in there, but then they do the opposite. Their actions, they may change certain assets or the nature of them, or they may, for example, enter into joint estate planning documents. Have you seen a lot of that? I know I'll have an example, a good example of that later on this morning, but are you seeing that in your practice and in WILMIC? And then the disagreement on that, and well, then why didn't the lawyer put that in there, or some language to that effect?
Do you want me to talk about that?
I mean, yes, ma'am.
Okay, yeah, that's a really good question, and it is something that we do see. And yeah, and it kind of goes to that foreseeability issue and looking to the future, because you are right. You know, I'm working with a client right now who's getting a divorce, and they signed the prenup, they put it in a drawer, and they really forgot about it. And, you know, the comment I keep hearing is, I never thought I would need it. I never thought I would need it. Yeah, so that is then a basis for the other side to say, well, you didn't follow it, perhaps, right? Depending on what the terms are. And of course, we have one reported decision on that, probably more, but the Brandt v. Brandt case, which is also fairly old, I think that was from the 1980s, and it came fairly soon after Button, where precisely that happened, where there was a marital property agreement, but the person who wanted to uphold it didn't follow it at all, created all sorts of joint accounts and so forth, and so it was thrown out. So yeah, that's another important piece that you know, could go nicely in a closing letter. Like, now that you have this, make sure to look at its terms from time to time to make sure that you're following it, because it does become vulnerable at the time of divorce if the terms haven't been followed. I'll give you another example too. I've seen some where there's a moneyed spouse and a non-moneyed spouse, and the money in the actual prenup itself, it says that the moneyed spouse will transfer funds to the non-moneyed spouse for each year of marriage during the marriage. I don't know if anybody else has seen those. And then they don't do it. They don't do it. They're married, they're happy, then all of a sudden they're not happy, then they're getting divorced. And so a challenge to the enforceability is, look, we had this agreement that said you were going to transfer funds to me, you never did, you didn't follow it. Why should a divorce court uphold it?
And that might be exactly the reason, Marta, the courts disfavor these, I think, a little bit. They just need an opening, and that would be certainly enough. I was trying, when you asked that question, I thought I had something in there, and now I found it. Can the parties identify the assets that the agreement controls at all times? And you're not going to be faulted as the attorney because the client didn't do that. But where you could fall into it is you didn't advise them and have a letter to prove the, as I advised you letter is so important. And in fact, the trial that I was talking about that we had in August, the client was clearly advised about the importance of exchanging the financials, and the jury attributed contributory negligence to the client, not our lawyer, because the advice was clear in writing and had been offered, and the client chose not to listen to it. But we were in trouble if that wasn't documented in the as I advised you type of format, just as the attorney could be for the misman or the commingling of assets. Not your problem so long as the client was advised and decided to do something totally different. That's their problem.
And that's exactly a bolded statement before they sign any marital property agreement from our office saying this is only this only holds up if you treat it as we've written it and not change the nature of your assets or any kind of other assets without speaking to us first. So obviously, clearly, I've seen that before where we want to make sure it's clear that they have to continue, if they're going to treat it separately now, they have to continue treating it separately for all times.
I would
And
say,
I think that's really hard to do too in practical terms, because you invest in some, even like your 401ks. I know that you have rollovers, you have different institutions that buy out other institutions, and the longer the marriage, the harder it becomes to really trace all those assets. I've seen.
and I think the discussion in the last few minutes, prompted by Mike's question, really emphasizes the importance of Rule 1.4 and communication and how you go about doing that. And Brian's absolutely right. The IAY letter, as I call it, it's not necessarily to cover your butt as the lawyer, but it's also to be sure that your advice is clear. And so, when the claim comes, and I guess it also emphasizes the importance of file retention. When the claim comes many years down the road and you don't remember all of the conversations that you had, and client says you didn't do this, and you say, oh yes, I did. Let's go to that IAY letter, that letter that explained exactly what you said and how you said it. And then let's not even bother with what client says and lawyer says. We've got it there in writing. And that is, as was illustrated by the case that Brian just mentioned, that was very important. And it certainly had an impact on the jury in that case. So all good points, all good ethical considerations, all good practical considerations and legal considerations. Great question, Mike. Thanks.
I think.
Can I just add one other?
Yeah,
can I
absolutely.
I was just going to add one other comment about sort of this tracing idea, and that is, I've also seen some marital agreements that talk about marital contributions, right? Or a percentage of contributions from one spouse to the other, for example, to a residence, right? So husband and wife are going to live in a shared marital residence. They have their separate property, but they're going to have that. But then they have some complicated formulas about contributions and how they treat the equity at the time of divorce. And that's all very well and good, but boy, oh boy, as time goes on, again, that's a pretty big burden to try to go back and trace it all to figure out who contributed what and come up with those percentages. I mean, some people are into it, right? But in my experience, most people are not and really don't want to spend the time having to go back and do that kind of audit. It's pretty intense, or it can be.
This is kind of a wild card question, but I wonder, only because I think it comes up perhaps more in our second session in estate planning documents, but are there serial marital agreement writers, who write one and realize that things change a few years down the road and then want to write another one? How does a pre-existing marital agreement affect one that's to be drafted now or in the future? Does that ever come up, or is that just not a consideration for this? In other words, when a will is written, I hereby revoke all prior codicils, wills, and everything else, and we're going to write this one.
Well, I put in, and I'm curious, Marta, you're actually out there doing it, but some of the expert testimony in the case we had, there was some indication about a change, allowing for a amendment in the case of a significant change in circumstance, parties' health, employment, otherwise, I don't know that that's the standard of care, but it was thought to make that maybe more enforceable by showing that there would be an amendment based on the change in circumstances. Is that something you, as a matter of course, include, or is it a certain case-by-case basis with?
Definitely case by case, and yes, and sometimes when there's a negotiation, and I personally believe that having a prenup for a short marriage is a lot safer and more natural and enforceable. And the longer the marriage goes, the less likely that it will be enforced because of, the long-term nature of the relationship and probably the changed circumstances, the commingling, the partnership, the having children, right? The sacrificing a career or what have you. So sometimes that's a big dispute, right? Because one side wants a very straightforward, here's the deal. And the other side is like, yeah, I get it if we're not married for very long, but the longer it goes, the more protection I would like. So one way to possibly deal with that is to have a review or a sunset clause or, this idea of amending in the future. Yeah. So I don't think it's a bad idea to think about doing that because in truth, life will change for folks and they very well may have a different opinion about what the terms of their financial circumstances should be when they've been successfully in the marriage for a period of years.
What Marta just said, if that could be part of the closing letter to the client, would be perfect. So not exactly word for word, but that general theme, so that right. 10 years from now, they don't say, well, you never told me this might not be upheld. Well, yes, I did. At the time we drafted it, I said these were some of the risks, especially because you were being a little bit, well, I don't want to use the term, but you were being a little greedy in terms of what you wanted and how you wanted the agreement drafted. You're right. I advised you of the risks. Then you're good. I think it's defensible, and we proved it at trial in August. One of the other things that came out of the trial that we had was this, and there were different expert opinions on this, as to whether the attorney needs to be at the, quote, how they put it, the signing ceremony. Signing ceremony was the word used. But when the agreement's executed, our expert would tell, and the jury agreed, that the attorney doesn't have to be at the actual execution. It may be best to do so for reasons, for questions that may come up, but what's your practice, Marta, in terms of, you've drafted it, you're satisfied that the three elements of Button have been established, they're going to meet at the other spouse's attorney's office to sign. You don't our expert would say you don't have to be there for that.
I totally agree with that. I totally agree. And then especially now, after the pandemic too, right? I mean, people weren't even gathering together and, maybe you do this via Zoom or what have you. So yeah, I mean, maybe if you want that extra level to just avoid the argument and the potential idea that, oh, this person wasn't there, therefore I didn't know what I'm doing. But yeah. I don't think that resonates very well when you've had the independent consultation. What was it for goodness sakes?
One other quick, I know we're down to 5 minutes, right?
Got about 5 minutes, yep.
Another interesting thing that came out of the trial was that, as I mentioned, there was an attorney that was retained then to handle the divorce / defend the marital agreement. They didn't draft it. They were there to try to defend it, though, because it was in their client's best interest. It brings up Celtrek in that ultimately that attorney that was to defend the marital agreement didn't do a lot of things with full benefit of hindsight, which is what every legal malpractice claim has the advantage of against the attorney that's actually in the trenches doing the work at the time. But it was clear, and it looked very poor at the time, I have to say, because that attorney didn't for example, at the hearing in which the marital agreement was being challenged, didn't call either our attorney that drafted it or the spouse's attorney that was representing the spouse at the time, who indicated and at the legal malpractice case testified that my client fully understood it, entered into it freely and voluntarily, had no issue with English as a language, even though that was intimated later. Had that person been called at the time of the invalidation, that other attorney, there's a good chance that would have been validated, but they weren't. So now this falls squarely upon the second attorney who didn't do certain basic things. And I say that with full benefit of hindsight now, but this jury sat there and listened to the spouse's attorney that wasn't called at the time of the invalidation challenge, who was a very good witness and cleared up any dispute as to what the understanding was of the ex-spouse at the time of the execution. So it ties in a lot of things into legal mal, including this last clear chance cell trick idea. There's a case whereby if you get into a case later, even if Marta made all kinds of errors maybe in the initial drafting, it could have been salvaged, or execution maybe didn't cover things well, could have been salvaged by the attorney that was trying to defend the marital agreement. And so anyway, it was an interesting study on legal mal. And I think the takeaway is, if a marital agreement is being challenged, you need to identify what is the basis of that challenge so that you can correct that or resurrect that. In this case, the freely and voluntarily thing would have been totally dispelled had that attorney been called at that hearing. And the other last piece on that is, if you are the drafter of a marital agreement that you understand now is being attacked in a divorce, call your carrier. You're going to be now deposed. Call your carrier so that you have representation, because you're trying to be helpful. Maybe you're going to walk yourself into a problem where you're disclosing protected attorney-client information that you don't have the authority to, or you're not properly supposed to disclose. You might walk yourself into a possible claim by trying to be helpful, not really seeing what's behind the inquiry. So that's my long takeaway from the trial.
The case that Brian is referring to is Seltrecht v. Bremer, 214, Wisconsin 2nd, 110. It's a 1997 case. We have only just a couple minutes left. Marta, I'll give it to you to have your parting shot and offer whatever suggestions, guidance, advice, or recap of what we've covered in the last hour and 15 minutes, and we'll close up from there.
Well, thank you. This has been a really good discussion, and I always learn things every time I attend these, and try and up my best practices, right? So I really appreciate the discussion. You know, there is one matter I handled. This is kind of off subject a little bit, but thinking of best practices and so forth. Short marriage and no prenup, right? But it was a very short marriage, and there was an estate to protect there, even though it was a short marriage, because one party had, you know, I want to say maybe an estate of $400,000 or something, and the other party had zero or a negative estate. And they were married a very short time, and then it was a disaster. And I asked the client, you know, who had more money, why didn't you get a prenup? He said, well, I was told there wasn't enough money to actually protect, which I was kind of surprised at that. And I mean, I didn't explore it fully, and I don't think it was malpractice, but you know, that's just something to think about if you are advising people about the merits of a prenup. You know, how much are you trying to protect? What are your reasons for doing it, and so forth. But a prenup would have been helpful in that particular case. So I don't know, that's just food for thought. But the other thing I'll say is that if you're working with people, you know, these prenups have a lot of legalese in them, and I wish we should start a movement to try to make it more English friendly and get rid of some of that legalese. And sometimes we have very sophisticated clients, but they still don't even know what they say, especially when you talk about, you know, what's individual, what's marital, what is commingling, how do you keep it separate? it gets really, really complicated. And so trying to simplify these things can be helpful to people so that they really understand what it is that they're doing. Because I can't tell you the number of people, they look at these documents, their eyes glaze over, it's 12 pages long, all these different clauses, and some of it is probably to protect us, right? But it's really important for these folks to know what it is they're signing. And that applies all across the board. So thank you for the opportunity to share some thoughts with you. I've appreciated the discussion.
Yeah.
Thank you very much, Marta. Brian, did you have one parting shot?
What Marta said, I think, is key, because that simple, and the understanding is to satisfy a button, you have to have proof that it was knowingly, fairly, and freely entered into by the parties. And if they testified, like Marta just said, "Oh, I didn't really know what I was signing, and it wasn't explained to me," that's enough for the judge to say, "Well, I'm going to invalidate this. You haven't proven to me that it was knowingly, fairly, and freely entered into." So I think that's great advice, Marta, and it's best protection for you if it's challenged, and you have to explain what was the client's understanding about what they entered into.
Excellent. Well, Marta, thank you. Thank you very much. Much appreciated. You've brought some good information to our policyholders, and we really, really thank you for taking the time to be here. Enjoy
you.
Texas. Enjoy the better temperatures, and get
I'll
back home
try.
safely.
I'll try to, look out the window and think of all of you with all your snow up north.
Yeah, I'm sure. Try not to giggle.
Take care.
All right. Thank you.
Bye.
And thank you, Brian. Appreciate it. And we will take a break until 10:15, and then we'll be back with Michael Maas, and we'll pick up with estate planning. All right. Welcome back, everybody. And thank you for joining us for the first session. I thought that was a good discussion with Marta. And thanks again to Marta for helping us understand issues related to family law and the impact of ethical rules on that. And thank you, Brian, too, for your inherent genius. It's always good to have you here, Brian.
Thank you, man.
So our second program is titled, Hey, That's Mine, Avoiding Legal Malpractice and Ethical Considerations in Estate Planning. And we'll talk a little bit about the sorts of claims and the real uptick in claims that we've seen in estate planning at WILMIC in recent years. But I do want to introduce our featured speaker for this program. Attorney Michael Maas joins us. He's an attorney. He's a judge advocate major with the U.S. Army Reserves. Michael he owns and operates Heritage Law Firm, an estate planning and elder law firm with offices in Green Bay, Appleton, Shawano, and New London. Michael believes that everybody has a fair plan, whether they have nothing or the most complex documents. His law firm philosophy is using plain language to educate clients and families on their estate planning options and allow them to choose the right plan based upon their goals, values, and objectives. Attorney Maas began his legal career in 2006 as a civil litigation and business law attorney. For the last 12 years, he has focused exclusively in the areas of estate and trust planning, disability and Medicaid planning, and probate and trust settlement. Michael has a Bachelor of Science in Finance with a minor in Economics. He served 8 years in the U.S. Marine Corps in the 90s and commissioned as an officer in the U.S. Army JAG Corps Reserves in 2010. Major Maas has served in various roles in the U.S. and also deployed to Poland as an international law officer from 2017 to 2018. Michael is a member of Wealth Council, a nationwide collaboration of estate planning attorneys and tax professionals. He's also a member of the Wisconsin Council of Estate Planning Attorneys. Having somebody with a plain language approach, I think, is appropriate, especially given the last comments that we got from Marta. You know, we should form some kind of an organization to help reduce legalese, of course. Welcome, Michael, and thank you for being here. Looking forward to hearing more from you. So jumping right into the outline and the materials that you have, will you ever have a malpractice claim? We have this statistic, every lawyer will experience 1 to 3 claims in their career. That doesn't mean, I don't think, a full-fledged lawsuit, all the way to verdict, like Brian and I just went through this last year. In fact, we very seldomly see trials. I think that's true of civil litigation in general. So that was a rarity. But a claim is defined as many things, and Brian, chime in if you feel necessary. But we define it in our policy, in the WILMIC's policy, as a claim, a potential claim, or a grievance. Now, last hour we talked about grievances and what they are. There's a pretty specific definition of grievance in the rules of professional conduct, it is that. It is something that is filed with OLR. It doesn't have to be fairly sophisticated, certainly not as sophisticated as a complaint that might be filed in court, but it is a grievance and an allegation of a violation of one of the rules of professional conduct. We want to know about those things so that WILMIC can help you as our policyholder get in touch with grievance counsel, get appropriate representation to guide you through that process. And we can sort of, a lot of times there is overlap. A grievance is not necessarily malpractice, and malpractice is not necessarily a violation of the rules of professional conduct. But they do have some overlap, and there are times when one can lead to the other. So to the extent that your insurance company can help you get out in front of that, repair whatever the issue is, and fix it before we go on, that's one of the things that we do want to know about. A claim can also be a claim, the obvious one, which is the angry letter from your client saying, I'm going to sue you, you did this wrong, put your carrier on notice. Certainly that is a claim. The less obvious one is a potential claim. And the potential claim, in our definition, means basically a set of facts and circumstances that a reasonably prudent lawyer would conclude might lead to a claim. So I think the point there is with respect to a claim and what it might be and how many and how frequent they are is stay in touch with your carrier. reach out to Brian. You know him now. You've heard him talk for an hour. You realize he's a nice guy, and he'll definitely do his best, to try and help guide you through a pretty difficult situation. And that's certainly our goal in providing excellent claim service. So yes, the claims are out there. There aren't really good statistics as far as whether it's applicable to every single lawyer. In fact, I think it's a fairly small percentage of our lawyers, our policyholders, who actually do experience a claim, but nonetheless, they do happen. Other considerations, and one of the things that we talk about with the statute of limitations, and I'll hand it over to Mike here to be a little more specific about it in a minute. But there may have been nothing to trigger the problem, so it remained undiscovered. And I think that's especially appropriate when we're talking about estate planning, because when you are drafting estate planning documents, you're drafting something that is going to execute and going to happen, well, I guess from the client's perspective, hopefully many years in the future, but at least, some time in the future. And so it may not be known, and it wouldn't even be discoverable. And we talked about the discovery rule last hour. May not be discoverable unless the provision that you drafted in your estate planning documents actually kicks in. The elements, we did go into these in some detail last hour, so I'm not going to spend too much time on them. I'll let Mike talk a little bit more about when non-clients, this is definitely the practice area, estate planning, where a claim brought by a non-client, either in the form of a disinherited beneficiary or someone else who may be affected by the estate planning documents, comes into play. And we'll talk a little bit more about that. But again, the idea of a lawyer-client relationship, it is on the lawyer to clarify any confusion about whether or not an attorney-client relationship exists. So do take that seriously. And then we did talk fairly in depth about negligence, and proximate cause and actual collectible damages we can touch on a little bit. Proximate cause is where in the malpractice world we talk about a case within a case. For a plaintiff to be successful in a malpractice action, a case alleging malpractice against the lawyer is part of the battle. The other part is proving that there was some kind of collectible damage or damage in general that was caused by the error. In other words, would you have been successful in an underlying case had the lawyer not made the error? And that's how we think about proximate cause in the world of legal malpractice. And then actual collectible damages. Okay, you've done everything. You've satisfied the first three elements. You've either established attorney-client relationship, or some sort of standing to bring the action in the first place. You've established that the lawyer made a mistake and that it caused some damages, but can you actually collect that amount? In other words, if there was an error that was committed in the estate is $10, are those collectible damages? Arguably no. But the case doesn't get better just because the lawyer made a mistake. So if you weren't going to collect much underneath it all, you're probably not going to collect anything against the lawyer. That brings us to the statute of limitations discussion, and I'll go through the statutory provision and the case that's in your materials real quickly. 3 years. It was changed, I believe, in 2017 or 2018 from 6 years to 3 years. Woohoo! But it doesn't really matter because of Bleecker v. Cahill in an estate planning context. This one was a little bit different. It applied to a real estate provision, but the idea is that even though the error was committed in 2003, the claim didn't accrue until 2013. In that case, when the lessee exercised an option that resulted in reasonably certain financial loss to the plaintiff. What happened in that case was a lawyer drafted an agreement between, I believe it was Aurora Advanced Healthcare and the developer that provided for a 20-year lease, with Aurora having an option to terminate at the end of 10 years. Well, the cost of the development of the real estate was amortized over the full 20-year period. So when Aurora terminated after 10 years, they only made half their payments, and the developer was out of luck. So brought hey, lawyer, you drafted this. I was expecting money to be coming in for the next 10 years. Court said, no matter. lawyer. You don't have, the statute of limitations doesn't apply here. The discovery of the error didn't happen until Aurora terminated the contract. That's when we'll start the clock ticking. So really in that case, it should have been 6 years. What should have been a 6-year statute of limitations had 10 years added to it. That is, I think, a good opportunity to transition to Mike to explain how that would have a little more impact when drafting wills and trusts.
Thank you. And I don't know if this first slide is up. I'm assuming if it's on the screen, it can be seen by those that are on the webcam. This is not a joke, actually, sort of, because this is called the slide in the military, the Army especially. And what that means is Afghanistan stability and COIN is a word for counterinsurgency. So, for the entire time that we were there was dynamics between those two. How do we make it stable, and how do we, prevent or operate counterinsurgency? So, and this was actually provided to us, two-star general. I look at it as can be a good a diagram for all of the different issues in estate planning and settlement. I mean, you don't know where they're going to come from, when they're going to come. And like that case that was just talked about, it can come at any time. And actually, another good example of that is this next slide. And if I can, I don't know if it's, zoomable, but I'll just, give you some information about this. It's not necessarily a will, but again, there's a lot of documents out there that affect people at death. And one of them is real estate planning and deed planning. So this is a joint tenant deed. I call this a Hunger Games deed. For those that have never heard that term, it's the last to die wins it all, right? Well, that's a joint tenant deed, if you didn't know. This was done in 2004, not by me. I wasn't licensed then, so there will be no claim for malpractice. Thank you. But it was done by the small town attorney that practiced forever in that small town. I'm from a small town. I love that. But it was mom and dad giving the farm to the boys. Dad wanted the farm to stay in the boy's name. Well, it probably won't anyway, because the boys may have daughters that get it, or they may sell it, and it's not always going to be in their last name. But that was the intention. The agreement between the mom and dad was, mom didn't necessarily think that was fair, because if you knew the background, there's 3 daughters involved as well. So there's 5 kids, but dad wants to give it to 2 boys. So the negotiation was this: well, we'll put mom on there. And then the 2 boys, so mom can give her 1/3 to whoever she wants when she passes. That's what she told me. Well, I had to inform her, unfortunately, in 2020, that's not, dad had now passed. That's not how it will work, because this deed does not allow for it. There is no will that can control this type of property, because it's very clear to a lawyer, typically, maybe not even to a lawyer sometimes. I've seen lawyers that don't know what a joint tenant deed is. That's a problem. But it does say in this one, joint tenants with full rights to survivorship and not as tenants in common. You can't make it more clear there. You don't even need the not as tenants in common, but they did that way. But the layperson may not even know what that means. Okay, joint tenants, when I die, I can still give my property to my 3 girls. Well, that's not the case. There's 200 acres of farmland here, so I don't know if you're from my area. I've been seeing farm sales for $7,000 an acre. So if you can multiply that, that's $1 million or more in farmland. The situation is right now, I only met this client to look at their powers of attorney and make sure they had the right powers of attorney. But this came with it. And subsequent to that, there's been a lot of family turmoil and questions. And in addition to this deed, along with a lot of other deeds, I received this deed as well. If you notice, this is a quitclaim deed that was signed in 2020 before I had met this client. I think I met her at the end of that year. And this is actually another deed from one of the sons, or from mom to one of the sons. And no one knew about this. And obviously it wasn't never drafted by a lawyer. It was drafted by the son. And it's not void on its face, but it's voidable. So what the son had done is convinced mom to give him some more of that land just to him when she died, as between joint tenants. Well, on a joint tenant deed, unless all three sign, it's not a deed. It's not a transfer because they all three have to agree. Well, this has produced even some more issues inside the family. Not only do the three girls not get it, but then the other son is unknowing to the other brother, trying to get more land. So you can see where this all goes. Right now, obviously, the three of them can still agree to make changes, but they all three have to agree. And let's just say they're not talking to one another and haven't been for the last year. And where do the girls sit? Helpless. All because from the beginning, it may not have been explained, or it may have been something that she didn't even know about. So again, just in other areas, like that first slide shown, this might have been up in the left-hand corner, not even dealing with a will, and it's just not contemplated. So, and I think that gets us to the dabbling part, on the outline. If you wanted to cover that, Matt, a little bit.
Yeah, and let me back up. This is a perfect example of how the statute of limitations is going to affect an estate planning practitioner. The joint tenant deed was drafted in 2004. Didn't really become an issue until 16 years later, and even then, if they've only begun to talk to you, Mike, that becomes an issue. Is this something that gives rise to a claim? I don't know. Maybe it is. Maybe it isn't. But the point is, that these things can stick around for a while, and sometimes longer than we would like them to.
I will say the attorney has since retired.
Okay, well, hopefully
They drafted all this,
and maybe that gets to Brian's point in the first program, which is there are what are called extended reporting endorsements available. Extended reporting endorsements are commonly called tails, and so especially if you are in real estate. If you are in estate planning, family law, those are three areas where an extended reporting endorsement is very important. And the reason is exactly like we're discussing now, that errors can come to light many, many years later, and that even though you may be retired, hopefully you still have an insurance policy in place, and that would be responsive to a situation like this. Brian, do you have anything to add on tails and the importance of them in estate planning practice?
No, other than Michael, well, I will say something, but you brought me back down to my December blah again. I was feeling good about being done with it. But this is exactly the kind of claim that we see whereby say that attorney thinks they're just drafting a quitclaim deed. I'm not doing estate planning. Well, they intertwine. And then when they come to the third attorney and say, I just want a will that's just going to give divide my estate equally between my 5 children. If you have no idea about some of these documents that are in the background, that might be the entire estate. What might be being divided at that point might be $100 that they have in the bank account.
Exactly.
The value is in these transactions that occurred, which brings up the point that Matt brought up on the cell track, which comes up time and time again, is that there are sometimes when this stuff's out there, and I don't know enough to be worried yet, Michael, about what you did, but where you say, listen, I don't know that I can jump in and help you at this stage. I'm not familiar with what's happened in the background, some of the real estate transactions. Apparently there's some dissatisfaction amongst the children. We've had a very recent case, and Matt knows about it too, where our attorney didn't do anything wrong. The will was perfectly drafted and divided property as indicated, but the attorney was then criticized for not understanding the background, some of these transactions that were out there that changed entirely where the estate was going to go. And unfortunately, the fee that this attorney realized from this simple estate transaction was very small. The headaches that he inherited were huge. So getting in late, and I know nothing about Michael's situation.
I'm going to state on the record right now, WILMIC does not up my liability insurance. That The only documents I have drafted for this client are the disability documents.
Yep.
Now, if I do choose to I would represent mom. The brothers would have, full rights to get other attorneys, and then they would be signing some liability and some acknowledgments before I'd even draft another deed for the three of them. There's additional considerations here. If I change this deed, that changes mom's estate right now, and that could potentially create some Medicaid issues, because right now it's a joint tenant and it's over 5 years ago. Whereas if I change a deed and I put it back into mom's name of any sort, now it's back in there for Medicaid. That's why these deeds are so important to understand from the beginning too.
And you
don't up my rates, please.
No, but it was a great. I'm glad you brought this, because so often I don't do estate planning. Well, you are impacting an estate. You're a real estate lawyer or a family law lawyer, but some of these you're a divestment attorney, elder law, all these issues get broiled in there. But you made me think of that when you said the daughters are left out to dry or some, I can't remember. Well, they're the ones that are going to get an attorney that brings the malpractice case, non-client, but they're disinherited potentially. Their only avenue might be to go after the attorney. That's their last effort. But
even mom says this is not what I wanted.
Yep.
So they have mom on their side in all this. Yeah.
But that attorney that I think you mentioned, he may have retired.
This attorney for this first deed, yes, retired, and that's why. And I don't know what happens. I don't ever take over other people's practices for this very reason, because you never know what's out there.
But Matt, I got going on a little different angle. But when your question about extended extended reporting endorsement, if you're in the area of real estate, this now comes to someone, and I know that's not your angle, is to pursue legal malpractice, but this was drafted, what was the date of the signature?
This first one was 2004.
So that, arguably, if there's, the mistake was made in '04, it's not going to be discovered until maybe now you write a letter to that attorney who retired last year. How is he protected? Well, if you're practicing in real estate, it's wise to have that coverage extended so that you're protected if and when a claim comes up. And real estate is one of the areas where it can be much further down the road when it's arguably first discovered, because this deed in and of itself, there's no error in the drafting, signature, execution, all that.
The one by the attorney, no. The one by the brother, yeah, he had to write it. He probably copied this online.
Yeah.
And you can see his writing in the middle of it. He was probably doing it, and he was shaking because he was nervous, probably because he knew what he was probably doing he didn't seek legal counsel, so.
Yeah. So you just want to make sure that, and call your carrier if you're with us. Hopefully we'll walk you through it, and it's a choice you can make. You don't have to have tail coverage, extended reporting endorsement, but if you practice in these areas, that's exactly why you would want that coverage to protect you and your clients in the event that there's an error or a claim made.
And I think this all goes back to, people think dabbling is a young lawyer. It's not. It can be a lawyer that's been practicing for 30 years, but doesn't know the Medicaid issues, or doesn't know or doesn't communicate, fully with the client. It's anyone with inexperience in knowing how this all affects, I think.
I think that's right, and I think that's why your coin diagram, your counterinsurgency diagram is I'll just call it the spaghetti bowl, is accurate. All these things are intertwining. There's a lot of considerations, a lot of things to think about in the execution of your professional services for the client. And it explains, I think, why this is one of the riskier areas of practice.
I should have mentioned that estate. If we didn't, it's been the number one area of claims now, 3 years running, and I don't see that changing. And that's your area of focus. I mean, it used to always be personal injury plaintiffs' work was one. The state probate trust has passed that by, in both in terms of number of claims and the amount of money paid to resolve them. And I don't know that that's going to change. I mean, it's just because of things, exactly what the types of disputes that you're bringing forward.
I think that's exactly right, Brian.
Yeah.
just to emphasize your points, in 2020, it was from 2010 to 2020, it was about 14% of all of our claims in terms of frequency were against estate planning practitioners. And in 2021, that jumped, nearly doubled, to 25%, and that's continuing now in 2022. And, the discussion this morning or earlier this morning, and even now, we're describing, even in just the context of the suits, the claims, the issues that come up, evolving family structures, increased lifespans, disenfranchised beneficiaries, and others. All of those things are complex family issues and real estate issues and property issues, and are only adding to the complexity involved in an estate planning practice. And that will lead us into dabbling. And on page 3 of your materials, we talk about it. And the Supreme Court rule that applies is 20:1.1 and its competence. And I think it is self-explanatory, so I won't read it to you. But that comment, I think, is particularly important. And that is that you don't necessarily have to know everything about an area of law if you want to get into it. But you do need to make yourself competent. And you can do that. You're smart. You're a lawyer, and you can study and you can figure it out. But perhaps a more effective way of going about making yourself competent is to associate with somebody who does know what they're doing. Call Mike and say, hey, I've got this new and interesting estate planning client, and I think that I can do some good work for him or her. Is this something that, you can help me with, or, how can we collaborate, or what sort of resources do you have, or are you aware of, that would be available to me, to be able to make myself a better lawyer and be able to better represent my client. Mike, what are your thoughts on dabbling? And I mean, I've got some of them, but other than don't do it, is there something more that people can do or lawyers can do to help themselves in this respect?
Well, and that's where I saw the general incompetence. I mean, if the will is competent or it's been executed correctly, it's got the minimum formalities and it's done, that doesn't mean that it's not going to be a liability issue for all the reasons we talked about already. And I see this not only with those, but with powers of attorney. Is the state-free form the best a lawyer can do? In my opinion, if a lawyer, and I see it all the time, charges a client for a free form and puts their name on it, I consider that malpractice myself. Just because the free form doesn't do certain things, it's very general in nature. It may be good for an emergency use, but from an estate planning perspective, it leaves a lot of holes. And that's where I have some examples just, through this is I say, on page 4, section B, under the durable power of attorney, I have a $70,000 provision. What do I call that? Well, the state-free form does not have any kind of language to allow clients to, make decisions for Medicaid purposes. It is simply you can pay the bills and you can do this with the real estate and you can pay the taxes. And that's cost a client of mine about $70,000. And it wasn't the situation where you had a wealthy client trying to shelter their assets from the big bad state. It was a wife whose husband had a stroke at 62, and she was not able to, under the law, take advantage of the spousal impoverishment rule to allow her to get some of the assets on her column and then also seek Medicaid benefits. It cost her $70,000. They had maybe $150 total. So that's a pretty expensive power of attorney when the client is crying and understanding that there's nothing that can be done because husband had a stroke and is not capacitated. So again, stuff like that. It may or may not, I will not say this for sure, been the same attorney who did that deed. I'll just say that.
Okay, fair.
Small towns again. Same thing with a $25,000 provision in a power of attorney. Every power of attorney that I draft and have signed has some type of accounting and disclosure, even between the kids, because kids fight too. And if there's not one in there, it is considered default private matter because the agent or the principal who signed it didn't put a provision in there, so the agent doesn't have to disclose anything. Well, that might be a problem if your oldest child is not sharing information and stealing money, or the son-in-law is stealing money from your account and selling your house, and then you have to go to court. And that's exactly how much, well, approximately it costs for me to file a suit to fire the son-in-law after proving that he was in fact a thief. I mean, that's where the DA can take that up too, but they normally are looking at more serious matters. But having a provision in there, it may make all the difference, even between your kids. There's dynamics between those kids as well. In fact, that's what I deal with every day. The oldest son or the oldest daughter, all those things. So even in those things, there's issues there with powers of attorney during life.
Mike, we've got a specific question, and I want to jump in just to make sure we address it, and that is from Victor. And he says, what role is there for educating the executor/administrator of the estate to address the mistakes in estate planning about assets unintentionally excluded? In parentheses, to include those assets in the estate despite a property deed that allocates the asset outside of the estate. Is there liability to the attorney for that, quote, education?
And this is where I'm going to try and answer the question the best I can as far as not knowing all the details. But obviously, if you're settling an estate, you're responsible for whatever is in that estate. If there was property that wasn't part of the estate, obviously that's separate from your, you can, I'm assuming, give them, I guess, the law on that. And this has happened to me before as well, and it's one of the examples in here. It's where I'm settling a trust with a house and farm, and then the house on the lake. And mom had a large brokerage account that was beneficiary designated that wasn't part of the trust, or maybe it's not part of the probate in this question. So Victor's question was, it's part of the estate or probate. Well, I don't have any duty because I didn't do the beneficiary designation. I only met this client after her death, but that doesn't mean you're not going to have some issues there. Because the same people that are in the trust settlement are the same people that were disinherited over here. For some other reason, like a beneficiary wasn't updated. That's exactly what happened. There was an older lady, she died, she had 4 kids, but one of her sons died before her. And it wasn't a car accident. He was a cancer, battling cancer for a couple of years. So there was an opportunity to make sure things were in order. But again, what she didn't do was update her beneficiaries on her brokerage account so the event of one of them dying before their children would receive that part of the account. Well, the trust had that in there, that language, if one dies, their children receive it. But JP Morgan Chase doesn't have those options, I guess, for $1.2 million brokerage accounts. I said that right. So they lost out on $300,000. And that doesn't make it easy. I know that probably Victor has experienced this as well. Those are not happy people when you're settling a trust with them either. But it's communicating with that executor. And I always say this, I am not the client for the one executor or the personal representative or the trustee. I am, but I'm also, my higher, I guess you'd say, duty is to the estate of that person. And that's written right in my fee agreement. There's conflicts of interest already there. In fact, this trustee was the oldest son. He was the farmer. He is he says how it goes. Guess what? At the first meeting, I said, that's not how this works. You don't dictate values of land or property or any of that stuff. You're responsible for transferring or distributing, but you don't dictate any of the rules there. And I made it very clear. And if they don't want to, I guess, understand that or, appreciate that, then I wouldn't take them on as a client. So he understood that as long as all the parties agree what the value of land is or the value of assets are, that's one way, or they can go out there and get appraisals and then agree on which appraisal is the closest. But until that's done, he doesn't just decide how it gets distributed. He wanted his son to buy the home at a certain price, and he said, this land's worth this, and the lake house is worth that. I said, that's all and good that you think that, but that's not how this works. So again, I think, Victor, in the beginning is, that communication is important. And knowing, yes, what's part of the estate and what's not, but also it still might affect, the estate settlement too, especially if there's some disinherited maybe even unintentionally disinherited beneficiaries.
Sure. You mentioned your fee agreement, and John has a follow-up question, and he says, Mike, I know many clients are worried about the Medicaid or long-term care planning aspect of estate planning. Do we still need a CYA, I would say IAY, but CYA in our engagement agreement informing them their plan will not protect their assets from the costs of long-term care?
Absolutely. If the plan doesn't address it, say you did a will plan with powers of attorney, and you're going to be also following that up with beneficiary designations or, those kind of things, it should be very clear that we're not protecting their assets. The only time they can, and then be very careful if you're looking at doing that. Because there's a whole bunch of different issues with trying to protect assets. And I always say this, unless you filed a Medicaid application, you may not want to try and do Medicaid planning because you don't know all of the rules per se on how that works. And even if you do it, don't do it the easy way. The easy way is to do one of these deeds like this on the screen, a quick claim deed to the kids. But guess what? 2 years down the road, if one of them gets divorced, now mom's house is gone potentially in a divorce hearing. Or, not my client, I've seen and heard, 8 years down the road, everything is fine. They get into a fight and daughter sells the house on mom. She's got to move out. Sorry, you did a quick claim deed. It's gone. So there's just so many issues in Medicaid planning. But if it's an estate plan that is just for death only, make that clear to your client that it's just for death and there's no protections in certain areas. But if you are doing it, that's where you want to be very well educated or have a support system with you in order to do that proper Medicaid planning.
Excellent. Anything else that you wanted to say about dabbling, or you, Brian, even?
Everything is about dabbling, by the way. For me, it'll all come back to that.
Okay. I know you had some examples, and I didn't know if you wanted to share them.
I do. I mean, this is where the dabbling of the person themselves. The first example is a will, and I redacted it, but it is a public record as a probate. The biggest thing you notice not the biggest thing. I know it's hard to see the very bottom, but the first time I saw this, I said, because it was signed by the testator. Her name is Carol Jean. You can see it at the top. It was signed by someone named Catherine as a witness, I believe. And then it was notarized. But what's the law in Wisconsin? It's 2 witnesses. And notaries, they can do them post-notarial acts too, right? So if you take something to a notary, I believe it is, and you say, I attest to this signature, I'm not going to re-sign it, but I'm going to show you my ID, and I might show you my signature so you can match it up. And a notary can actually notarize something even though it's been signed. That's not a witness, though, at the time of signing. So could be all those issues. Well, again, it starts out, pretty normal. Kara Ann is mentioned in here a couple times. She's getting something, and then of course she wants her ashes to float down the lake at a certain time of year. Of course, we had to have that in there. And then all of a sudden you see language like have Schumann family right in the middle. Have Schumann family take whatever they want. Period. What does that mean? Mm-hmm. I mean, if they want everything, they get everything. And then maybe this qualifies it, though. Debbie and her family, I don't know who Debbie is. Dave and his family, okay, I hope they know. And then they get a brass bed. So I don't know what, it goes on and says, this account goes, can pay for the, and then she gets, 10%. Oh, we got to add we got to put some charities in here too. Make it more easier for us, right? We have a cancer Buddha box. And then all of a sudden she wants to create trusts for her great-grandchildren. Boy, that's 8 different trusts there. We got to give our laptop and flash drives to someone, and our sewing machines, and the vehicle has got to go to a charity as well. The last sentence in there, I want you look at that. Stamp and coin collection and the sheepskin are Dewey's. Okay, I mean, that's However, if you read this, I don't know who you would think if she's got any kids, or was she married, was she, all that stuff. Well, yeah, she did have 1 child. It was Dewey, the last person she mentions in her entire will. So, and this is a big deal because he is a biological son. If there is no will, he gets it all, right? So who's going to try and contest this? Dewey. That was my conflict there, because do I have a duty to tell Dewey this? Or what do I tell Dewey? Kara is my executor who I'm working with, and I have to tell her what my issues are. This actually went to the judge, and we notified Dewey that he has a right to come to dispute or contest the will. I even talked to him personally and said, listen, you need to take this. I gave him a copy of it, as I had to give everybody a copy of it. I said, take this to an attorney and get their I guess you'd say recommendation on what, take it, not to any attorney, take it to someone that does it. I couldn't give him a recommendation because but he didn't show up for the hearing. I let the court know of all these issues on the record, so they knew I wasn't trying to, and I told them all that record stuff, and they did accept it too, because they can judicially notice that, okay, if no one objects to it, we're going to accept it. So we actually had to go through and give everything to the, I did not pour any ashes in any lake, just so you know. WILMIC.
Did the Schumann family take everything but the bed?
Yes, I believe they did. And in fact, this is where it comes down to, does this make even sense? Is it economical? It wasn't a large estate. Yeah, she had a house on a lake, but it wasn't a very big house. It had maybe several cats and dogs and a lot of issues there. At the end of the day, by the time we got to the grandkids, I petitioned the court to allow us to put it into, UGMA accounts, the Uniform Gift of Minor, because it was uneconomical to create these trusts. And just by 8, kids. So, but yes, I believe they got the brass bed, and there was no other issues. So that's just one example of someone doing it themselves. The next example is the next level up. Someone went to a legal aid person, and I don't know down here, up there in Shawano, Green Bay, there is a Native American reservations, and they have individuals that are willing to do wills for their members. Right off the bat, you probably see a red, this is redacted. Why? Oh, because they put his Social Security right on the front page. I've never seen that before, and I hopefully never will. Enrollment numbers, and he lists, I'm not married, my children are this, 4 kids. Okay, it starts out pretty normal. Next page it goes down to, and I have some red here. I hereby, this is a personal items, okay, to my sons, these 2, to be distributed at their discretion amongst my children as they see fit. Again, we're back to that. I'm giving it to them, but then I want them to do you really want them? And by the way, unknowns to us, there's actually not 4 kids, there's actually 7. He just didn't list 3 of them because he didn't want to. So again, we're leaving out information and opening the door to others, so that becomes an issue. Again, it goes down personal, specific distributions of specific accounts all the way through it. And then there's the nice residuary. Again, if one of his sons dies, it goes to the other son and shall go to be distributed at his sole discretion. Well, what do you think that's going to be? If a son, thankfully both sons survived Dad. I don't have those issues. And, we're actually finalizing this probate. There's not been any claims or objections. The sons talk to the other ones, and they're going to work it out after we're done. So again, another one, obviously, these are just the signings of the will. This is another one where it's in one of my offices, hometown. It starts out great. I'm a widow, no children. It talks about a niece there, and then names co-representatives. That's sometimes an issue. You have 2 to deal with. Now, most courts are not going to want to deal with 2, so we try to say who can do it, and the other one may resign unless the other one can't do it. This was my biggest problem on this. I wanted to show this specifically today because, it's a big deal. 1, 2, and 3. If we read that, equally among all the nieces of Harold was her husband, equally among my nieces and nephews, that's Olive, who died at 99 and 11 months and 2 weeks old. And then the next one is also 1 equal share to be distributed equally among the children of this one person. 3 children. So when I read, we are lawyers. We have to either cross out or put a line there or try to figure out what and then the next one is if any niece or nephew died, or then their kids get it. How would someone like this read? If anybody can answer, when you read this, how would you read this? As far as You have equally, and then also one equal share to these 3 kids.
Clear as mud.
Yep.
Yes, right? And then if any of these, I could look at it 2 ways, okay? Equally, that's 1/3 of everything, right? 1/3 of the estate to these 3, 1, 2, 3. And then it says if any of these other ones passed away, then they get whatever share they would have gotten up in these 3 categories.
Yeah, this is a great example because the mere fact that if there's an argument of which now there's an ambiguity, fees are incurred, it's challenged, the lawyer's going to be faulted, even if it works itself out with the cost of the litigation, because you didn't make a document clear enough that it forced litigation, and the fees can be depending on the size of the estate, but they can be sizable. And I think you can't get around the argument. They would be an expert that says the mere fact that this was litigated was because it wasn't clear, and that's the attorney's fault. And therefore, the fees are going to be looked to as reimbursement and damages.
Well, and this is a 2006 will, so it goes back, 14 years of when she passed. Especially now, let's add some more complexity to this. This was a heritage farm, and that's what I call them. Some of it was owned during the homestead period, meaning it was homesteaded by this family, the Hoffman family, in the 1860s or 70s. And they kept owning more farm. They never had any kids. So now let's just say Harold had 10 nieces and nephews, and Olive had 6. Let's say another one of them died beforehand. Now you have 19 beneficiaries in this mix. And now you have 300 acres of prime farmland to deal with. So the estate was a little over $2.1 million. So to fight over that would be very easy, because 1/3 of 2 is about $700,000. That's what these 3 could argue they should receive. They are going to split, instead of getting a 1/3 share of 1/17. Think of that. A 1/3 share of 1/17 or 1/16 is a lot less than a 1/3 share of, $700,000. I did try to contact the attorney who drafted this, and he pulled out his 1974 will that they had drafted and clarified it in a letter to me, and no one objected. I mean, the nieces and nephews knew what was clear. I mean, they assumed what was clear, thankfully. This estate has closed, and it's past the 6 months from closing. So, but these are the issues that can come up at any time.
But Michael, if you're the attorney that drafted it and you get a call from Michael, can you just open up and share, this is what he intended, and who is the client, and what did he say before he signed it? Now you're walking yourself into a problem. And that's where you need to pick up the phone and call your carrier.
And probably Tim Pierce or...
Yeah, exactly. Yeah. Again, I think goes back to, you're trying to be helpful. Michael's not trying to, he's not out to sue you. That's not what he was trying to figure, you're trying to figure it out.
Absolutely.
But being helpful on the other end, okay, why is he calling? Because it's not clear, and there's a dispute regarding the distribution of this estate, and it's sizable. That's a potential claim. It's so mad that you try to, because the potential claim is that you didn't make it clear in the drafting.
Yep.
That's not what Michael's after. He's trying to figure it out. But that's where you have to stop and say, I'd love to help you, Michael. I just don't feel comfortable. Or maybe it's Michael calling to set up your deposition.
That's right.
And then you say, anyway.
Or sign an affidavit.
These are all great examples of, what pitfalls exist when you're in an area that maybe you shouldn't. Now, I don't know anything about all these lawyers.
Well, I'll say this law firm, has the 4 names on it in a small town. It's been there forever. In fact, I think the lawyer's the oldest one in the history of the county still practicing. Not sure of that. But so people, they go to those small firms. They don't know the difference. I mean, not the difference, but it's this language that matters so much, especially when you have situations where all of my nieces and all of her nieces. Now you're talking about lots of individuals. to manage, to not control, but to provide, clarity for them, when it can get very difficult.
Yeah, that spaghetti bowl comes to mind.
So if you had been a lawyer in 2006 with this part, how would you have done that differently without getting too mucked into the?
I don't think on this will, number 3 is useless. Just take it right out, because it automatically says if one of them dies, it goes to their children, right? Number 4 says that. So what's that 3 in there for in the first place? Unless it was for a different purpose, So that's how when I draft, I make sure it's extremely clear, extremely not overly, again, plain language, but extremely clear. So I look at number 3 as something that was maybe a good intention. So that they were trying to make it more clear, but they actually made it very ambiguous and very problematic. It's already in there. Every one of your nieces and nieces will be, in fact, during the probate, one of the other nieces died. So then I had to get a certified will from the state of Washington, and go through her estate and the rest of it. But again, that's how drafting can be very. You do the best you can, and if someone wants to be very complex, and they have a complex estate, I may not even agree to draft a will for probate. This is where I tell clients, your situation can only be, your goals can only be done through trust planning, where we have the ability to provide much more, language, and it keeps it outside the court system, in my view.
And you know that because this is the area you practice in. So
yes, sir.
When you see these things, do you immediately recognize them as, oh, this looks like an attorney who probably was getting into an area that he or she was not all that familiar?
Well, not necessarily. I look at it as bad writing, bad language. They could do this for years, but again, if you write one bad sentence, it can cause some serious damage, especially in will planning, because you won't find out for many years to come. So yes, that's where the reason why I met this client even before she passed away is because she was in assisted living. And the agent, the power of attorney, came to my office to get some recommendations on how to continue paying for her care. And then she subsequently passed, and we were hired to do the estate settlement. So yes, but I see stuff. If I see this, I don't necessarily go right to that. I say that's just sloppy. It's not all attorneys can write, by the way. If you find that out, you probably know that already.
But Tom's question is a good one, because you're held to the standard of care that a reasonably prudent lawyer practicing in that area. And unfortunately, an excuse isn't, well, I don't do much in the area of estate planning. that doesn't change the standard of care.
That's right,
No.
Brian. And that's one issue, right? Is when they're maybe dabbling, or when the work falls short of the standard of care. I want to pick up on one of the comments that you just made, Mike, and that was, there are times when a client's objectives cannot be met with the particular legal tool that they had in mind. Where a will fails, only a trust can address it. I think it sums up what you said. And when I introduced you, you talked a lot, and it's clear, that you try to use plain language when you can. So that brings us to Rule 1.4 in communication. I have the quote in there, the single biggest problem in communication is the illusion that it has taken place. But it sounds like you go to great lengths to be sure that you communicate with your clients, not just, to understand them, but also so that they understand you, and put together the best estate plan that can accomplish their goals. So what can you share about communication, how you do it? What are important tips for our policyholders to pay attention to when they're having their initial meeting, throughout the representation and closing, to meet those rules and those obligations under 1.4?
Yes, and it does start from the beginning. Not a lot of attorneys do this, but my firm offers a free initial consultation up to 2 hours. Why do I do 2 hours? Why not a half hour? People say that's, a little bit long. Well, if I'm going to do estate planning for someone, it's going to be a discussion. It's not going to be a, this is what we do. It's going to be a, and I start out every meeting, talking about them. Are you married, family, kids, what, goals, desires, dreams. All those things are part of that. And what I'm doing as an attorney is listening to them just talk about their family. If you get someone talking about their kids, you're going to learn a lot about them. You're going to learn the kid's gone through a divorce before, or is in maybe some issues, or has some of those things out there. And that's why, my staff calls me Chatty Cathy, because I will sit and talk to someone. And I think, as a son of an automotive welder, my dad always said, if you can't explain it so someone can understand, then don't do it. If you can't explain how it's done, then you shouldn't be doing it. So if someone can understand you, then that's something that you have to work on yourself, not them. So that's what all those discussions.
Are you trying to gauge competency and, to ask a different way, do you meet with the client alone, or do you ever meet with the client and a son or a relative?
Good question, because it's in here too, conflicts of interest and communication. So if I do meet with a client and their child, I'll let them know up front that we can communicate like this, but at some point I'm going to have to talk to just mom or just brother or whoever that person is. And I'll excuse them from the room. Sometimes I might do it right away. If I have 3 kids in there and they all drag mom in, or dad, and he is older person or a more wise person, I may do it right up front and talk to them. Obviously, the kids are maybe just trying to be helpful, but I'm extremely careful when it's just one of the children bringing the mom in. Because I got to figure out what's going on here. What are her documents say ahead of time? What's it right now? Why are we making changes now all of a sudden? And try kind of gauge that. And it is a interactive, where you're trying to figure out because I don't want to be the attorney that changed mom or dad's documents, and now that person starts doing the wrong thing. But yes, it's a communication, and I'm not necessarily looking for incapacity unless I see it. With a lot of clients, they're anywhere between, I have the young clients and very old clients. So,
Michael, I think that's a really good point, because I know Brian has run into many claims over the years in which the lawyer made the mistake of letting almost an entire family sit in on those meetings, and they all have different interests. And I know, Brian, you could talk forever about all the claims that become problematic because of that. So I think your point is a good one.
What about, Michael, where son brings dad in and pays the bill then, and is also a beneficiary, or maybe the main beneficiary?
We also have that in our fee agreement. If payments are from anybody other than the client, we have to have that acknowledgement and that acknowledge it. I don't see that very often where the sons, because we're looking at, the parents, and normally they have the assets. But if we do see that, that's where we take an extra step and have them sign a separate agreement along with that. But it's in our initial as well. So we try to, I think I have a 3-page, letter engagement or agreement of representation, which obviously is very important, especially we talk in here in the outline, it talks about spouses. Even spouses that have always been married, there is a conflict there, technically. Having joint representation, they have to waive that because under Wisconsin rule, we owe duty to each client. What I tell them is I'm representing both of you based on it makes sense economically to do one joint estate plan. However, there is no confidentiality between the 3 of us. And I always joke, if your husband calls and tells me a secret, I got to tell you that secret too. And they laugh, but it's actually serious. Outside the room, yes, we have confidentiality, but inside this room, we're all big one happy, client.
Do you have notes, or how do you, 10 years later, you get brought in, what was the goal? How did the meeting go? How do you remember?
It's all written down. So whenever I meet with a client, I have a worksheet that I have in front of me that we're discussing, and then I will write down what maybe some of their goals are, what I heard, or what some of the issues are at that time, and that always gets put with their client and scanned into an electronic file. And I do not, the 6-year, I mean, it doesn't apply. I keep all my records no matter what. I haven't put them into electronic form yet, but that's the direction we're going. One thing on that is, and I put this in here as well, is we do not keep any originally signed documents. I know that's part of this. I've seen this before, and I know the same attorney in the same town probably has a vault of signed wills in their vault. What are they going to, I mean, I guess they're going to have an open house at the end and say, come get your will, and you have, 20 days, and if you don't, it's going to the burn pit. I don't know. But I give my clients 2 separate binders. I don't even use envelope system. I use a binder system because it's much probably harder to lose those binders. So we have set up systems and processes to try and, clients work through that system and process so that we can gather all the information and their desires. We have them write out what their desires are on as part of the questionnaire too. So, but at the end, we have that final engagement letter as well. I do not charge clients to call me if they have a question. In fact, I put emergency instructions in their binders. So if something, and this is where they even authorize the kids to call me because they're normally the ones that might be nominated as agents. So we keep that door open too, obviously up to a certain point. If it's a child that's not the named agent first, then we can only provide so much information. Yes, I'm working with your brother or your sister as the agent. And, any communication has to go through the agent as well. But I'll make sure they communicate with you as well. We want that open communication. Because that's where it often breaks down with disinheritance. There's no communication whatsoever. And then it becomes an issue. The only one, I wanted to show this last one too, because it actually might wrap up. I don't know how much time do we have yet?
We've got about 10 minutes left.
Oh, that might be perfect. It'll wrap up, I think, for the group, not only all of the issues we talked about in the first one, but also in this case as well. So I'm going to push on here. This is it right here. So I'm just going to set it up, the scenario, just like you're back in law school, right? You got to spot the issues. Well, this was a second marriage. Husband was 70, 2 sons, and then the wife was 60, and she had 2 daughters. At the time of the signing of the trust, this was the ages and the family. That was in 2003. So I just want to look at the actual document. Sometime after they got married, they had a premarital agreement as well. It was similar to looking as this, because I think the same lawyer did that. And then at some point later, they decided to sign a joint trust. And the joint trust included some of the assets that the husband brought to the marriage in it, which I probably would have never advised, but in any event, they put it in there, and they put some language in there. So it says right here, this is the real estate, and this is all about the husband's. I think it was. You can see 100 acres and a lake house. See that family land? He had owned that for 40 years before they got married, probably, maybe longer. It was in his family, but they described it and said, okay, at his death, all the real estate described on Schedule B, which was they called it the lake house and land, shall go to Jeffrey. That was his son. That was the goal, and that was the agreement. I've had this land in our family. We got married when I was 70. You were 60. My son should get my land. Okay, in the event that Jeffrey sold predeceased, well, we kind of changed that. What if he died before me? Well, then I'll give it to you as my wife, I guess, if I have to choose one. Okay, but if she were to pass him, then it goes back to one of his other sons, which he didn't really want to get, but he put him in there just in case. I guess there was a lot of lawyer discussion about that. But it's pretty plain and clear there, not a problem. So what about during life? Because this is a joint revocable trust. What happens, during life if something comes up while they're living? We go to the next page, which is Article 3 at the very 8 at the very bottom. This is where problems might start happening. So during the joint lives of the grantors in red here, this trust may be amended or revoked by both parties. Okay, if I can get her to agree, maybe we can change things. However, it says right here, after the death of a grantor, this trust may be amended or revoked by the survivor, that might be, except that Russell shall only have the right to amend or revoke Article 3. That kind of makes sense, right? If he passes away, we don't want the spouse to amend that article and say, oops, no, sorry, Jeffrey, you don't get it. I'm giving it to myself. We don't want that. But what about during life? What if, something, does he have apparently he only has it if she dies, then, because remember, you can only amend or revoke this if they both agree, if they're both there. So he has no rights just to come in based on this language just to change things, even for Article 3. So again, that might be a problem. And then the next one, again, this is where it gets even better or not. In the event of a grantor shall become incompetent or incapacity during the joint lives of them, the competent grantor, the one that's not incompetent, shall have the right to amend or revoke this trust, except that Russell shall have the sole power to amend or revoke Article 3. That really begs the question. The only time he can amend this Article R3 is if she's incapacitated. That's how I read it. There's nothing in there next to that during his lifetime. Maybe put a clause in there that says at any time, Russell, no matter what, or his agent, or assigns or heirs, can amend or revoke Article 3 because it's supposed to go to him no matter what. So again, some pretty, bad language, I call it. And then even more so, what about some other issues like this? This is how I met this client. My office got a phone call. He was in my parking lot and needed to see me right now because the cops were chasing him. Him and his son, of course, Jeffrey. He's 87, at this time. And this is why. Because there was a lot of issues of it, not incapacitated, capacitated, whether or not, he could leave the house. She was, the wife at this point was telling him, you can't even come here and pick him up, calling the cops, just ironically, the wife, her daughter worked for Adult Protective Services. You know what they do? They protect people, right? A lot of old people, right? So every time he would leave, she would call her daughter at APS and they would call the police. It's kind of nice to have that power, right? During COVID, you really use the COVID rules to say you can't even leave your house. So again, the next step was they actually filed, I didn't show you the caption of it, but it was, he was the petitioner, she was the respondent, a restraining order. Because she, more or less, she was not letting him talk to a lawyer. It says all in this stuff here. And that's where it all started. But then what happened after that? They did get divorced, unfortunately. And what wasn't, did you read any language? Did we read any language in here about his land and divorce? Oops. If it's not in there, guess what? And they put it in a joint trust. The court found that it wasn't in there and awarded her a 1/2 interest in all the land and lake. So he had to buy his lake house back from her, which is a big deal when you're 87 after 17 years of marriage. There's other things in here, but that's the kind of the gist of it. You see all this stuff all kind of goes together. It could have been any one of a number of issues with that trust. It just happened to be the divorce, and I hope I never get a phone call from my parking lot that the cops are chasing me. I need to see right now, and I don't do criminal law, so, but you can see how, again, we go back to the, I would just go all the way back up to the first slide and say, be careful in estate planning, because you just don't know. And I hope that some of this information was helpful.
Oh, no, it absolutely was. And thank you for blowing up my outline. You did a great job, and it was
we didn't touch everything, so maybe we'll do some more in the future.
No, that's not what I meant at all. I think you covered everything. You just did it in a much better and much more eloquent and much more powerful order. So I thought you did a great job, and it was terrific. The only thing that I guess as a parting shot, and Brian, we do see some claims come in, and we have a fairly lengthy discussion, at least in the outline, under ORIC, claims under ORIC and its progeny. Can you think of some to share, or at least some tips that come from what we've seen, Brian? I know that the few claims that I handle in the office, along these lines, come from disenfranchised beneficiaries, and ORIC really seemed to, the exception, liabilities imposed on an attorney who acts negligently in drafting or supervising the execution of a will, and a lack of privity will not bar a claim by a disenfranchised beneficiary. I think the plaintiff's bar maybe saw that as an opening in the door to pursue on behalf of beneficiaries who are, completely inherited, or who are maybe just unhappy, as some kind of means to pursue a claim. And I think that door was that little crack that was opened by ORIC was effectively held shut by the McLeish case that's in the materials, so that you can't just say general unhappiness, and so the testator's intent was missed by you, lawyer. There has to be more to it than that. And so I think there is some creativity with theories like undue influence and others that are present. And when Michael talks about all of these issues, and he's exactly right, and how they intertwine and where they go, it is, I guess, an issue of concern. So, Brian, do you have anything along those lines, so that we can make sure we cover everything in there that might be useful?
Michael, his diagram is supportive of the thought of why estate probate trust is number one. But a couple of things. I know I've had comments recently from attorneys that are frustrated with claims whereby apparently there's, at least in this attorney's mind, attorneys that are handling disinherited beneficiary claims on a contingency fee basis. So there's really nothing to lose for this person to claim, I was disinherited, you didn't follow mom, which is unfortunate for the practitioner, because they have no skin in the game. And the attorney has a potential, when you mentioned the size of some of these estates, a third of $2 million gets, and by the way, we're seeing bigger firms, some of the big firms digging into this, so that it's a risk. I think Michael's last example is a perfect one, where estate planning can get into so many different areas of real estate, criminal law, family law, elder law, divestment planning. If you're doing a very limited role, make sure that your scope says that, so you're not dragged into, well, you didn't consider all these other things. You weren't considering the real estate. No, because I was retained to do a very small, specific thing, and that's what the scope says. And at least that gives you an argument that that wasn't what I was asked to do. Because otherwise, if you're just doing a general overview, open the door to Michael's diagram, that you could be criticized in ways that you never even anticipated, that you didn't even look into.
Absolutely.
And I would say the last thing is having a good process. I mean, that process is what you follow for every client, to check off every box so that you are providing them with the information they need. And by the way, I refuse to do certain things like draft deeds to kids. That's one area I don't go into. I tell them there may be a lawyer in town that might do that because of the liability issues there. And then also, if you're limiting your scope, just put it in there what this is not taking into account, and they may want to seek other advice about this before doing it even.
Absolutely. Michael, thank you. That was so much more powerful. Brian and I do a great job of spotting the issues and commenting on the things that we see come across our desks, but we are not practitioners, and you are, and that was extremely useful. So thank you for your time and your energy, and the guidance and suggestions that you made today were terrific. That will conclude WILMIC's Winter 2022 program. Thank you all for joining us on the web mostly, but for those folks who are here, thank you so much for braving the weather and having a seat in here to join us. So thank you very much, and happy holidays.